Okay, people right in front of me, please disperse. We're gonna get started again. Uh, in our next panel, I've been informed in no uncertain terms that the district attorney for Manhattan needs to leave on time, and therefore I go to Manhattan a lot. There's no percentage for me in alienating the DA in Manhattan, so we need to stay on schedule. So I'm here to introduce our lunchtime speaker, Marty Stroud, and I think it was referenced earlier that one of the most difficult things for a system to do is to construct a process of self-evaluation and of learning from mistakes. And part of the reason that that's so difficult is that it's extraordinarily difficult to acknowledge and embrace and own a mistake when one happens. And if you look at other systems and how they've addressed this, there's a personal aspect to that and a systems aspect to that. The personal aspect of that is sometimes called the second victim scenario. And so if you think about a plane crash, for example, the first victims are the individuals on the plane that crashes, and the second victim in this example would be the air traffic controller that gives instructions to the plane that end up being bad instructions and lead to the plane crash. And so when you're managing an organization and you want to address errors, you have to take care of the second victims, the good faith people who nonetheless make an error. And in part it's because they define themselves as not making those mistakes. They define themselves as being perfect all the time. And so there's substantial challenges and fears when you are a second victim. The second aspect of this is the fear of punishment, fear of losing your job, fear of liability. And so organizations and systems construct a deny and defend posture to mistakes as an instinctive reaction. Now, it is possible to have a different kind of system. In 2001, the University of Michigan healthcare system changed its approach to the responses of patient injuries. They decided that rather than a deny and defend posture, they took two central observations. The first one is that honesty was indispensable for safety improvement throughout their network, and their goal was to become the safest health system in the nation. So number one, that honesty about mistakes was indispensable for safety improvement, and number two, that a short-term focus on financial risk of liability would impede the long-term improvement in safety, and in fact, that long-term improvement would more than outweigh any short-term claims that they were going to pay. And so they put a new policy in place that emphasized the prompt investigation of claims, open communication and agreement, acknowledgement of fault where appropriate with patients and families and their lawyers, and managing expectations regarding continuing clinical needs and dispute resolution. What they found when they embraced errors and communicated with them openly and transparently, continuing to litigate claims that they didn't feel were meritorious, but offering immediate and fair settlements in cases where they honestly thought that they were at fault, was that their rate of new claims decreased by more than 25%. The number of lawsuits decreased by 60%. The time to resolution of their claims dropped by more than a third, and their cost rates of total liability, patient compensation, and legal fees dropped dramatically. In addition, their scores on safety studies have increased every year since introducing the program, showing that when we embrace errors, when we acknowledge errors, not only do we get better results in terms of customer satisfaction, but we get fewer lawsuits because it's less, people are willing to acknowledge that humans make mistakes. What they are unwilling to abide is people hiding from those mistakes and getting into a culture of deny and defend. Marty Stroud, who I'm introducing now, is an example of that kind of quality in the criminal justice system, and it's a kind of quality that we see all too rarely. Mr. Stroud was the prosecutor over 30 years ago of a man named Glenn Ford, who spent 30 years on death row in Louisiana to be recently exonerated based on DNA evidence. I'm going to let him tell you the story, but what brought him to my attention, to our attention, and really to the nation's attention was an editorial that he wrote to the Shreveport Times in which he advocated aggressively for the state of Louisiana to give Glenn Ford appropriate compensation. He started it with, Glenn Ford should be completely compensated to every extent possible because of the flaws of a system that effectively destroyed his life. The audacity of the state's effort to deny Mr. Ford any compensation for the horrors he suffered in the name of Louisiana justice is appalling. I know of what I speak. And he proceeded to lay out an apology and an exploration of the system that I really couldn't possibly duplicate, and so I had to invite him to come here and speak to you himself. It was one of the most intensely personal, open, and honest expressions of regret and thoughtful explanation of how errors can happen in the system that I've ever seen. There was a video accompanying that I didn't read until yesterday, or didn't watch until yesterday, and in that video he said he really didn't want to go on a speaking tour. And so in that sense, I apologize, Marty, for bringing you here today. But we're absolutely thrilled that you've chosen to join us. Marty was raised in Shreveport, Louisiana, graduated from St. Louis University and LSU School of Law with honors. He was a federal clerk in the Western District of Louisiana and an assistant U.S. attorney in the Western District of Louisiana before becoming the first assistant DA in Caddo Parish, Louisiana. Since then, since 1989, he's been in private practice in civil and criminal litigation. Please join me in welcoming Marty Stroud.
I was given a microphone, and the gentleman that gave it to me asked, was I going to do a PowerPoint, and my staff in Shreveport would have laughed at that. Basically, I can get my emails and send my emails. It's a pleasure to be here in front of this distinguished group. This symposium is entitled Defining Quality in Criminal Justice, and I was thinking about that. If you put the Louisiana model into any study, it would probably crash a computer. In Louisiana, we elect our judges. We can contribute to the judges. The judges supposedly don't know who gives them the money, because you give the money to the quote campaign director, and then after the judge is elected, he has another function to retire the debt. And if you're in court and the other side happens to be represented by the campaign manager of that judge, in our state, that's not a conflict of interest. That's hard to explain to the client. It's a privilege to be here in front of this distinguished group. I must confess, I am intimidated by the amount of brain power in this room. Little did I know when I wrote the Shreveport Times about my involvement in the case of State Louisiana versus Glenn Ford, that it would ignite a discussion about the death penalty that has transcended the boundaries of my hometown and become a national topic of discussion. This was the first time I'd ever written to a newspaper, because I don't think much about letters to the editor. But in this instance, I felt that I had a perspective I could bring to the debate, since I'd been the lead prosecutor on the case. Well, I've heard a lot about transparency here, and I tell you at this time that is ironic. When I left yesterday, there was an article in the paper about transparency. The legislature in Texas has introduced legislation to maintain the secrecy of drugs that are used in an execution and the name of the suppliers that produce the drugs. The Texas legislature is about like Louisiana's legislature. There's a bill introduced in Louisiana this year to make it against the law for a 13-year-old to own an Uzi. So I don't know. We have a saying, I'm sure you've heard it, our legislature is often wrong but never in doubt. In my case, evidence was revealed that Mr. Ford was innocent of murder. Indeed, the motion itself stated that if we had known about this evidence in 1984 or 1983, Mr. Ford would not have been arrested, much less convicted and sentenced to death. When I heard this, I was stunned, to say the least. It was unconscionable that Mr. Ford had been on death row for 30 years, courtesy of the state's wrongful prosecution of him, and now he was being denied any compensation. And on top of that, Mr. Ford had recently been diagnosed with stage 4 lung cancer. This man had been dealt a bad set of cards, and one of the primary culprits was myself. And so the letter to the editor, when I found out that that the state was opposing compensation. But I want to go back to 1984. In 1984, I was 33 years of age. I would turn 34 in August. And I was in my 8th year of practice after having spent a year of clerkship with a federal judge. There are two things that happened that year that I still vividly remember. First, in 1984, the Chicago Cubs, those lovable losers who I'd grown very fond of, lost the national championship series in the best of 5 to San Diego 3-2. A crushing defeat for the Cubs, who lost an 8.5 lead to the New York Mets back in 1969 with a month to go in the season. You have to be able to endure pain to be a Chicago Cubs fan. The second fateful event was the trial of Glenn Ford, and it's this case and its aftermath that brings me here today. In 1984, I was quite full of myself. I was arrogant, self-absorbed, narcissistic, judgmental. I was full of character flaws, and I was the first assistant district attorney for Caddo Parish. I was a self-proclaimed fire eater, a bull in the ring, who was a protector or maybe even the avenger for the law-abiding citizens of the parish. I thought I was doing God's work, which is always a dangerous thing to think. And it's this attitude that I had when I walked into the courtroom to start the trial of State versus Glenn Ford. By the time I had literally worked myself up into a lather, I was ready to go. Back in those days, I had an unusual way of preparing for trial. After reading the police reports and examining the physical evidence, I prepared my rebuttal argument. I know that sounds strange. How could one possibly prepare a rebuttal before you knew what the defense was going to argue? I didn't care. In my mind, it was easy. My rebuttal was geared to appeal solely to emotion without letting the facts get in the way. I wasn't giving an argument. I was demanding justice in order to rid the community of a criminal element. I might be fitting a square peg in a round hole, but no judge was going to shut me down. If the judge said, if the other side argued and said it's prejudicial, my retort was everything we're doing here is prejudicial because that man's sitting here. And the judge very seldom overruled, sustained the objection. Now, I mentioned the frenzy I was in at the time of trial. Let me share what you did with what I did. On almost every morning, I listened to the opening scene of Patton, the movie, in which he addressed the Third Army. His first line was, got you in the mood. I want you to remember that no bastard ever won a war by dying for his country. You made the other poor bastard, dumb bastard, die for his country. Americans love a winner. The term hate is hateful to Americans. Americans have never lost a war, nor will they ever lose a war. Of course, that's back in 1943. The argument was exhilarating. I adopted arguments that I found in other cases. I used to tell the assistant who was going in with me, we're going to kick the enemy. We're going to hold his nose. We're going to kick him in the ass. We're going to kick the hell out of him and run through him like shit through a goose. So we were pretty fired up when we went in. Vincent Bugliosi, who prosecuted Charles Manson, I read a book of his, Till Death Do Us Part, that he put out before the Helter Skelter. And he had an argument, many of you may have heard it, that compared the defense to an octopus. And basically, he stated that the octopus didn't have a beak of a bird or the teeth of a lion or the tail of an alligator. It had what he described as an ink bag that would shoot out ink and allow a sort of murky substance and allow the octopus to retreat. And I would compare, like he did, the defense to that, and it said, during my next few minutes, I'm going to clear up the water that the defendant has created and bring the octopus back into the room to face justice. This argument worked well until one day I got a call from a teacher who'd been on the jury, and he said, and this description, by the way, was Victor Hugo's account of an octopus. And she said, "I like that account. Can you tell me what book it's in that he wrote?" Well, I was sweating bullets, thought about it. I said, "I'll get back with you." I got home that evening, and I asked my wife, I said, I had this lady call me and ask me about what book the description of the retreating octopus was in. I said, "I think it's either in The Old Man in the Sea or Farewell to Arms." My wife didn't look up, and she said, "Victor Hugo didn't write that. Ernest Hemingway did." I also, I looked it up and found out that the name of the book was Toilers of the Sea, and Victor Hugo was also one of the primary movers in the abolition of the death penalty in France. Glenn Ford was indicted for first-degree murder of Isidore Roseman. He was in his home. He died as a result of a single gunshot wound. There were no witnesses to the crime. The evidence against Mr. Ford was that he attempted to pawn jewelry from the Rosemans. Also, we believe that he gained access to the house because he was a yard man, and he let others in to assist with the burglary murder. The police learned from several sources that others had participated in the crime, with Ford's role being to gain access. That was never substantiated. Therefore, the only person that ended up going to trial was Glenn Ford. It commenced in early December 1984. Those of you in criminal law probably have heard the phrase, "You better get on the train before it leaves the station." In my area of the country, we say, "You better get on the train because it's fixing to leave the station." Aside of that, I was dating my now wife, and I called her one day to pick her up and said, "I'm through at the dorm. I'm fixing to come get you." And she said, "What are you fixing?" I said, "I'm not fixing anything. I'm fixing to come get you." She said, "Marty, what are you F-I-X-I-N-G?" I said, "I'm not F-I-X-I-N-G. I'm F-I-X-E-N to come get you." She said, "It's not in the dictionary." I said, "Yeah, it's in Webster's, the Southern edition." But anyway, the train left without Glenn Ford, and unfortunately, it was a train of injustice. It was fueled by hate and revenge. I was the chief engineer. Mother Justice undoubtedly was crying tears of sorrow as we sped down the tracks. Now, the attorneys for Mr. Ford had never tried a criminal case, much less a capital one. At that time in Louisiana, to be appointed on a capital case, all you had to have is 5 years of experience. They were not paid. They had limited funds for experts. One of their lawyers closed his practice for a month trying to get ready. The other one hasn't practiced since that time. These lawyers tried their best, but they were simply ill-equipped to handle this case. And I think they represented the best in our profession, though, because despite the odds, they represented Mr. Ford. Nevertheless, the trial was a complete mismatch. To again paraphrase Patton, as I told one of our assistants, we greased the wheel of our train with the guts of the defense as we continued down the track of persecution. I remember as a child seeing, I think it was Look magazine, on the front page, there was a picture of Italian tanks going into Ethiopia, and the Ethiopian warriors were trying to stop the tanks with spears. They were brave warriors, but a futile effort. And these attorneys in the case, I believe, were brave warriors, but it was a futile effort. They never had a chance. When I was in college, there was a song that came out, "The Nights the Light Went Out in Georgia, that's the night they hanged an innocent man." In the wee hours of December 1984, Glenn Ford was convicted of capital murder for a crime we know now he didn't commit. On that night, the lights went out in Shreveport, Louisiana. After the verdict, Mr. Ford was remanded to jail to await formal imposition of sentence. That night I went out to celebrate the victory. We congratulated each other, we patted each other on the back, we'd obtained a death verdict, we were the protectors of society, and we'd sent a sociopath on his way to the death chamber down in Angola. It was one heck of a party. Looking back on the party now, I feel nothing but shame. My conduct was obscene. It showed quite clearly that I had no business handling a death case. I had led the charge against an individual who did not have the means nor the assistance to defend himself. Obtaining a death verdict should not have been a cause for joy. The law allowed for such a verdict, but it was a solemn occasion. We were dealing with a human life, and yet I was too busy thinking about what the verdict did for my career, or would do for my career, to give the consequences of the verdict a second thought. I went home that night, told my wife about the day, laid down to go to sleep, and suddenly I was dulled by the emotion. What if Glenn Ford was innocent? I quickly pushed that aside. I immediately fell asleep, still secure in the belief that justice had been done. Glenn Ford was formally sentenced to death and transported to death row down in Angola. He would be in his tiny cell for the next 30 years. The condition on death row in Louisiana are next to barbaric. Locked down for 23 hours a day, 7 days a week, food was terrible, guards uncaring, lights dim, smell sickening, movement was restricted to that small cell. He was in a pure hellhole with little hope of ever escaping the injustice that had befell him. Excuse me. I left the district attorney's office in 1989 and went into the private practice, but I could not put the Ford case behind me. I could no longer contend that Mr. Ford had adequate counsel. I also could no longer ignore the issue of an all-white jury. When Ford was tried, a peremptory challenge could not be sustained on the basis of race unless it could be shown that the office had systematically excluded persons of that race over a period of time. This was an onerous burden that practically immunized strikes of minorities from any meaningful review. Batson, as we know, changed the law and held that race could be looked into, and that if challenged, the prosecutor would have to give a reason as to why he used a peremptory challenge. The case was sent back to the district court. A hearing was held. The district court found that there has been nothing wrong with the challenges, and the conviction was affirmed. But as the review of the case continued, I was becoming more uneasy about the strikes used in this case. Cattle Parish is 50% black, and there were zero African Americans on the jury. Now, that number haunted me. I was becoming more uneasy about the issue of race and whether our strikes really had been racially motivated. I struggled with the issue for a long time. I came to the conclusion that Ford deserved a new trial because, one, of the unfairness of the proceedings, and two, because I did not have an adequate appreciation of the race factor in the exercise of peremptory challenges. I did not believe that I intentionally excused anyone solely on the basis of race, but I confess, when I finally was able to strip away all of my defensiveness, my thoughts about African American beliefs concerning the death penalty did factor into my decision. And whatever you call it, intentional, non-intentional, racist, subtle racism, whatever, I was wrong. As I mentioned earlier, last year I was asked to attend a meeting with the district attorney, the first assistant district attorney, other members of the Ford trial team, and investigators from the sheriff's office. There we were told that the evidence had been discovered during the investigation of a cold case that Glenn Ford was innocent of the crimes for which he had spent 30 years on death row. Because the investigation of other offenses were going on, we were not given the name of the individual. We were further told that we had done nothing wrong and that no one was at fault for Ford's incarceration. I'm sure that provided a lot of comfort to Mr. Ford's family. I was stunned. I was nauseous. I broke out in cold sweats. I had convicted an innocent man. I left the meeting without saying a word and drove back to the office. Excuse me. I told my colleagues about the discovery. Everyone told me that I'd not hidden evidence and I was just doing my job. They were well-meaning, but their condolences could not mask the pain and suffering through which I was going. I was pleased that Mr. Ford was going to be released, but that did not give him back 30 years he spent on death row. Again, in the motion to dismiss the case against Glenn Ford, the state declared that had the evidence been known, Mr. Ford would not have even been arrested. Courtesy of the prosecution, the trial had been a mockery of justice, but Mr. Ford was released and was taken under the care of some kindly folks in New Orleans. And as I mentioned, he has stage 4 lung cancer. Mr. Ford applied for compensation, and it was denied. The state argued that Ford could not prove he was in fact innocent and that he had a prior record. When I heard that, I became angry and disgusted with the system. I could not continue to live with the contention that no one had done anything wrong. No one yet had taken any responsibility for the matter, a typical bureaucratic response. I felt I had to do something. So I sat down and wrote the letter. But something came over me and I began to disclose my demons. Writing has always been hard for me. It takes me a while to compose my thoughts in a coherent manner. But that night my pen flowed freely. It was a personal cleansing. Everyone around me attempted to console me with, "You were just doing your job." I must have heard that excuse too many times. Was my winning at all cost just doing my job? Was taking solace in Swain versus Alabama to support our use of peremptory challenges just doing my job? Was going through defense counsel with no trial experience like crap through a goose just doing my job? Was my final appeal to the jury in the penalty phase, during which I locked in on the jury's emotion in complete disregard of the facts, just doing my job? And what about the party after the death verdict? Just doing my job. These words, were just doing my job, were conveyed in an effort to support me. But in reality, they had no meaning. They were worthless. The Nuremberg trials make clear that serious wrongs cannot be immunized from justice by just doing your job. Now, obviously, this case is but a minnow in the sea of horrors of the Holocaust and the evils of Nazi Germany. But the principle is clear. When we deal with the fundamental laws of humanity, the retort to a violation of such laws that we were just doing our job carries little, if any, weight. And when I represented the state on a capital case, just doing my job, as folks said I did in this case, is an affront to the rule of law despite the well-intentioned comments of my friends and colleagues. I don't know if you remember the movie or ever saw it, but Al Pacino in the movie In Justice for All, during his opening statement, he's representing a corrupt judge, basically blackmailing him into representing him, and the argument itself was hilarious at the end of the movie. But he said, and he talked about justice, and he said, The intention of justice is to see that the guilty people are proven guilty and the innocent people go free. But we have a problem here, he said. Both sides want to win. They want to win regardless of the truth, regardless of justice, regardless of who's right or wrong. Winning is everything. As Justice Jackson, who was a lead prosecutor for the U.S. at Nuremberg, later wrote, the prosecution never loses if justice is done, an ideal that sadly has been lost in the combat of trial. And for any of you who have been assistant district attorneys and you've lost a case and somebody says, what happened? And you retort with, well, justice was done, you may not be working there the next day. During the penalty phase, Glenn Ford testified that he wanted to live in order that he could prove his innocence. This statement haunts me to this day. On cross-examination, I hammered the man. I suggested that all he was doing was belittling the jury and that he was showing no remorse for the crime that he had committed. But Mr. Ford was right, I was wrong. I had incredulously asked Mr. Ford if he thought the jury was wrong, and he said yes. Again, he was right, and I was wrong. As my errant judgments sunk in, I began to realize that one of the lead culprits in depriving Mr. Ford of a great portion of his life was me, and I did it in the name of justice. Which is very repulsive to me. I have met with Mr. Ford and apologized to him for my actions. He is an amazing man. He showed no bitterness or hatred towards me. He stated that I was just doing my job. He also said, well, if you'd represented me, I probably would have gotten off. And he said he couldn't forgive me at that time, and I understood that, and I told him that. I told him that I'd learned a lot from him, and he was surprised. I said, you shouldn't be, because you never wavered in your insistence that you were innocent and that you carried yourself with dignity over all these years. He is a hero in this case. He never gave up. When I left that evening, I felt that I had met a man with an inner strength of conviction to his cause that was stronger than that exhibited by anyone else I had met. The money after my letter had been printed in the Times. I got a call from one of my best friends, and he asked, have you armed yourself this morning? I said, what are you talking about? He said, well, I've been reading the internet, and there are a lot of people out there that don't like what you say. Do you have a weapon? If you don't, I'll bring you one. And we love guns in our state. I didn't need one. No, I wasn't threatened. I got a lot of calls. I've been called everything from a hero to a bum. I've been praised and cursed. I've been thanked and vilified. Just told some faculty members last night, probably won't be invited to the DA's Christmas party. But I reject the label of hero. I'm no hero. I was a man who simply tried to offer a view of a capital case from the perspective of a prosecutor and how it affected me. I'm in fact embarrassed by all the publicity it's generated, yet my hope is that prosecutors who are eagerly awaiting the opportunity to try a capital case pause and consider if there are any unanswered questions that created a nagging doubt. If so, you're not ready to proceed down the road that leads to the execution chamber. I believe before somebody prosecutes a case, that they should have a course in psychology. They should be tough. It's not just a matter of being able to present a case. You're dealing with a human life. And the question becomes, are you psychologically ready to do it? I think that there should be a requirement that people who try capital cases go through a course in psychology. I also mentioned last night to one person, I would also add as a requirement, if you want to try a capital case, and the last thing you do is that you go down to Angola and spend a week in a jail cell on death row, and then if you still want to try a capital case, be my guest. But I want to bring you back to my home of Shreveport, Louisiana, where I've practiced law for about 4 decades. It has some unflattering distinctions. The criminal justice system is completely broken in Caddo Parish. The United States, the last time I read, leads the world in per capita incarceration rates. Louisiana leads the United States in its per capita incarceration rate, and good old Caddo Parish leads the parishes of Louisiana in its per capita incarceration rate. So Shreveport, the parish seat, leads the world in per capita incarceration rate. The Indigent Defenders Program has no money. The courts are appointing lawyers who have no criminal experience to represent litigants. A lawyer who I know was appointed 2 weeks ago, even though he was suffering from dementia, and the court said that is not a sufficient cause to be relieved. I had a young lawyer call me and ask for help. He had been appointed and did not have a clue as to what to do. Shades of Glenn Ford were coming true again. No money for expenses. The lawyers weren't even paid, and the courts expect the lawyers to defend these individuals and to do it competently. Meanwhile, the poor and powerless are sitting in jail for months, not knowing what charges have been brought against them and not seeing a lawyer other than in court. It is a disgrace. We truly have a culture of incarceration and death in Caddo Parish. It is a mindset that stubbornly resists any effort of serious reform. Why? Because most of what it's done is out of sight, out of mind, and there's no transparency. I don't know if you read the response of the first assistant district attorney to my letter, and his response made the front editorial of the New York Times. When asked about the situation, his thoughts on the death penalty, he says, and I'm not making this up, you can go check it. He said, we ought to kill more people. The death penalty is not a deterrence because it takes too long. Society has a right to kill in revenge for a murderer's actions. That such drastic action was needed because we lived in a jungle, and Glenn Ford's lawyers were competent. This is a statement made in 2015. Now, due to the sudden death of the district attorney, that individual is the acting DA, and he intends to try as many capital cases as he can until the special election is held. I think that Glenn Ford was a victim of a system that still exists today. Indeed, the startling word of the acting district attorney shows that he relishes the opportunity to kill as many people as he can while in office. My hope is that these words of anger and revenge create a spark that lights a fire of condemnation against the current system in Louisiana. Indeed, the prosecutor's words, I believe, are exhibit one as to why we should not have a death penalty in Louisiana. My argument against the death penalty is based upon a 3-letter word, ego, E-G-O. We are human beings. We are not infallible. We cannot create a system that ensures the penalty is without error. My God, we've had 152 exonerees that walked off at the death row. 152. Where is the outrage on that? A gentleman before talked about the back end of the system. We've seen the demonstrations in Ferguson, in Baltimore, and other towns about what happens on the front end, and those are valid concerns. I'm just surprised that we don't see the same effort on the back end. I mean, how can such a system of 152 exonerees be defended? Is it an acceptable task for society, risk for society to take? If I went to a doctor for surgery and asked him about the risk of the surgery, and he told me, well, since 1972, only 152 patients have died, do you think I'm going to hire that doctor? I believe that the court should re-examine Furman versus Georgia, because if you remember that case back in 72, it said the death penalty is too random, too unpredictable, too arbitrary, but most of all, it is too inhuman. And it's still not objective, because the ultimate charging authority in Louisiana is a district attorney. And if two people are charged with first-degree murder, it's the district attorney who decides which one will he offer a deal to testify against the other individual. That, to me, is not objective. As I said before, the court has found in Louisiana that Mr. Ford was not guilty of the crime of murder, but he still somehow had blood on his hands. How, I do not know. It's another setback for a man that's had more than his share of sufferings in this lifetime. There's been blowback against me, yeah. But I'm not, I mean, it just comes with the nature of what's going on here. I was sued civilly and the attorneys raised prosecutorial immunity, which Embler versus Packman, I believe, is the case. People say, well, some say, well, you're just hiding behind the immunity statute. Well, I can assure you that it was not easy for me to admit publicly my faults in this case. But if foregoing the immunity defense would give Mr. Ford his life back, I would fall on that sword in a heartbeat. But we all know that's not going to happen, because time goes forward, not backward. I have self-reported to the Office of Disciplinary Counsel that my conduct during the Ford trial was a violation of Rule 8.4C of our Rules of Professional Responsibility, specifically that I engaged in conduct prejudicial to the administration of justice. And I asserted my belief that prosecutorial immunity did not apply to charges of unethical conduct, and there is no requirement of scienter. And I will accept without contest any recommended punishment. But on a more personal level, my conduct in that trial placed a strain on my reputation that can never be removed, regardless of what I want to do. I became a lawyer because I wanted to make a difference for others. I wanted to help people. My part in the destruction of Mr. Ford's life made a mockery of that ideal, and try as I might, I cannot erase what I did. I've heard it said that the primary purpose of government is to help those who cannot help themselves. As a representative of the state government, I failed miserably in this duty when the paths of Glenn Ford and I crossed. Glenn Ford meekly stood all alone against the unbridled power of the state that was unleashed against him back in 1984. He is still standing, and that is a testament to his inner strength of conviction. Blessed are the meek, for they shall inherit the earth. I have no doubt that there's a special place waiting for Mr. Ford after his life has concluded. It is my hope that with more openness, like we've talked about here, and transparency, more willingness to disclose for all to see the logistics of a death penalty case from beginning to end, fully disclosing the manner in which we treat human beings. Being candid that all too often we marginalize them to make them appear to be little more than a piece of meat that needs to be killed to better our society. Hopefully, if these topics are discussed at some day in the future, I don't see it happening in my lifetime, especially in Louisiana, the death penalty will ultimately die on the vine. Sister Helen Prejean, if y'all, those of you who have read the book Dead Man Walking, there's a statement in there she makes: our government cannot fix potholes. How in the world can we trust them to administer a death penalty that is fair and impartial? Well, there you have it. That's where I've come from in this matter. It's not a story with a good ending. I wish it was. But I have destroyed one life, and that is one life too many. And that's the cross I have to bear. I will have to answer for, and I really have no good answer. Despite everything that I've done in my career, I feel that in the final analysis, that trial in 1984, in which I was the lead prosecutor against a man who literally had nothing on his side, will stay with me until it is my time to leave this earth. I fueled the fire of injustice that, try as I might, I still fear is my epitaph. And that is the story of Glenn Ford and me. It's my hope, as I said before, that people that hear this story will think twice before running in to try a capital case or bragging about capital conviction. It is a huge responsibility when one takes on either the prosecution or the defense of a capital case. I don't know how many more failures we will have to endure before this country abolishes capital punishment. I really have nothing more to say. Thank you.
Marty, I can't thank you enough for being here and for being so straightforward and so honest. We heard in the earlier panel that the quality we most prize is courage, and I think you displayed more today than I've seen in quite a while. We're going to take 10 minutes and come back for the next panel. Thank you for your time.